Right now, there is a federal operation running across the United States, quietly, systematically, reviewing thousands of immigration applications, green card petitions, and benefit requests. And what USCIS just announced on February 18, 2026, tells us something very important. This operation is not slowing down, it is expanding. If you have a pending green card application, a marriage-based petition, an employment-based case, or if you came to this country as a refugee, what I am about to tell you could directly affect the outcome of your immigration journey. Do not click away. This is not speculation. This is coming directly from USCIS and the Department of Homeland Security, and it involves something called Operation Twin Shield. My name is Raymond Crivello. I am a senior immigration analyst and consultant, and on this channel I break down complex immigration developments into clear, fact-based analysis you can actually understand. Whether you are waiting on an I-485, navigating a family-based petition, or trying to understand how enforcement policy is shifting under the current administration, this is the channel that gives you straight answers. Before I go any further, I need to be clear about one thing. I am not your attorney, and this content is for educational and informational purposes only. Immigration law is complex, and your individual circumstances matter. Always consult with a licensed immigration attorney about your specific case. What I do on this channel is break down policy and give you the factual foundation to have a better, more informed conversation with your legal counsel. Now, let's get into it. Operation Twin Shield began in September of 2025. It was launched by U.S. Citizenship and Immigration Services, USCIS, in the Minneapolis-St. Paul metropolitan area. Over the course of just 10 days, from September 19th through September 28th, USCIS officers, working alongside ICE, the FBI, the DEA, and other federal law enforcement agencies, reviewed more than 1,000 immigration cases that had what officials called fraud or ineligibility indicators. What they found was significant. Out of those 1,000 plus cases, USCIS identified 275 cases of suspected fraud. These cases involved everything from marriage fraud to H-1B work visa abuse, student visa violations, and in at least one case, a connection to a known terrorism watch list. USCIS Director Joseph Edlow called the operation a, quote, resounding success, and then said something that every immigrant in this country should hear clearly. Any city should be prepared to be the next site for an operation of this magnitude. Let that sink in. But here is where this becomes critical. Most people assumed Operation Twin Shield was a September 2025 story. Finished, wrapped up, over. What the February 18, 2026 announcement confirms is that this operation never ended. USCIS has continued its investigations, and new arrests are still being made directly as a result of cases flagged during that original 10-day sweep. The most recent case involves a 45-year-old man named Morris Brown, a Liberian national who had been living in the United States since 2014. According to DHS, Brown entered on a non-immigrant student visa, which was terminated in 2015 after he failed to enroll in a full course of study. From that point forward, he had no legal immigration status. And yet, he managed to join the Pennsylvania Army National Guard. He went AWOL in 2015, was discharged under other than honorable conditions in 2022. He applied for a green card in 2020 under the Liberian Refugee Immigration Fairness Act and was denied because he failed to disclose his military service and had made prior false claims to U.S. citizenship. Then, in 2024, he applied to naturalize as a U.S. citizen, again fraudulently, again based on that same military service. And for more than 2 years, from May 2023 through October 2025, he worked as a corrections officer for the state of Minnesota, a law enforcement position. By claiming to be a U.S. citizen, it was Operation Twin Shield investigators reviewing his citizenship application that unraveled the entire history. ICE arrested him on January 15, 2026. He now faces removal proceedings and potential criminal prosecution for immigration fraud and false claims to U.S. citizenship. Now here is what this case reveals about the broader operation. And this is what many green card applicants are misunderstanding. Operation Twin Shield is not only about catching the most extreme cases of fraud. Yes, this particular case involves someone who worked in state corrections while having no legal status. That is extreme. But the operation also flagged cases involving marriage petitions, employment-based applications, refugee adjustment cases, and student visa holders. The 275 suspected fraud cases identified in September were just in one metro area over 10 days. According to USCIS's own end-of-year review released in December 2025, the agency's Fraud Detection and National Security Directorate, known as FDNS, completed investigations on more than 19,300 fraud cases since January 20, 2025 alone. They found fraud indicators in 65% of those cases. FDNS also conducted more than 6,500 site visits and over 19,500 social media checks, reviewing the online posts of immigrants for national security, fraud, and what the agency called anti-American concerns. This is a fundamentally different operating posture than what we saw just 2 or 3 years ago. Let me give you a hypothetical that illustrates why this matters to everyday applicants, people just like many of you watching right now. Imagine a married couple. Let's call them Daniel and Amara. Daniel is a U.S. citizen. Amara came here on a work visa. They met, fell in love, and they got married. They filed an I-130 petition and an I-485 application together. Everything is legitimate. Their marriage is real. Their documentation is accurate. But they filed quickly after meeting. Their address history is a little inconsistent because Amara moved twice during the petition period, and they have limited joint financial records because they were still combining households. Under previous USCIS processing norms, their case might have moved through the system with a standard interview and approval. Under the current environment, with pattern-based fraud detection, expanded FDNS reviews, and the posture established by Operation Twin Shield, their case could be flagged for additional scrutiny. They could face a request for evidence, a second interview, or a site visit to their home or workplace. None of this means they did anything wrong, but if they are unprepared, if their documentation is not tight, if their story has inconsistencies, that scrutiny could lead to a denial. This is why I want every legitimate applicant watching this to pay close attention to what comes next. Here is a structured action plan for anyone who has a pending USCIS application or who is planning to file one. Step 1. Audit your application for consistency. Go back through every form you have submitted or plan to submit. Check that your addresses, employment history, and dates match across all documents. Inconsistencies, even innocent ones, are now more likely to trigger additional review. Step 2. Gather strong joint evidence if you have a relationship-based petition. This means joint bank accounts, joint lease or mortgage documents, shared utility bills, insurance records with both names, travel records together, and photographs spanning the timeline of your relationship. The more contemporaneous and verifiable, the better. Step 3. Be aware of your social media presence. USCIS has confirmed it is conducting social media reviews as part of fraud investigations. This does not mean you need to delete your accounts, but be aware that your public posts, your listed relationships, your location history, all of it is now potentially part of the picture USCIS sees. Step 4. Do not work with unlicensed preparers. The enforcement climate has made notarial fraud and unauthorized practice of immigration law even more dangerous. If your case was prepared or advised on by someone who is not a licensed attorney or accredited representative, consult a qualified immigration lawyer immediately to review what was filed. Step 5. Consult a licensed immigration attorney before responding to any USCIS inquiry. If you receive a request for evidence, a notice of intent to deny, or any communication requesting additional documentation or an interview, do not respond without legal guidance. Now let's zoom out and talk about where this is all heading, because there is one detail most people are missing. Operation Twin Shield is not a standalone event. It is part of a deliberate administration-wide strategy to reshape how immigration enforcement works in the United States. The White House has issued directives establishing a new Department of Justice division specifically focused on national fraud enforcement. USCIS has been granted new law enforcement authorities directly from Secretary of Homeland Security Kristi Noem. The agency is actively hiring what it calls Homeland Defenders, a new category of agents with both adjudication and investigative authority. They received more than 50,000 applications for those positions since the program launched in September 2025. Operation PARRIS, which built directly on Twin Shield, has been launched to specifically target approximately 5,600 refugees who have not yet filed for adjustment of status, meaning their green card applications are either not filed or pending. These individuals are now under heightened scrutiny as part of what USCIS calls maximum vetting. What this tells us is that the infrastructure for large-scale, pattern-based immigration fraud investigations is now in place and growing. Twin Shield was described by Director Edlow as the first of many potential large-scale immigration fraud investigations. The expansion is not theoretical, it is operational. However, this protection may not be permanent, and I want to be careful about how I say this, because I want to be accurate, not alarmist. There are legitimate legal challenges to some aspects of these enforcement expansions. Immigration attorneys and civil liberties organizations have raised concerns about the lack of transparency around what specific patterns USCIS uses to flag cases. Director Edlow, when asked directly at the September press conference, declined to specify what data or criteria the agency used to identify potentially fraudulent applications. That lack of transparency creates a real risk that legitimate applicants with unusual but lawful circumstances could be swept into investigations they do not deserve. The INA, the Immigration and Nationality Act, still guarantees due process protections for applicants. Fraud findings must be supported by evidence and are subject to administrative appeal and federal court review. A USCIS denial based on a fraud determination is not the end of the road if you have a genuine case, but you need qualified legal representation to fight it. The courts have historically served as a check on overbroad agency action. We may see litigation challenging specific aspects of how FDNS conducts its pattern-based reviews, particularly around the use of social media surveillance and site visits without clear statutory authority. But those challenges will take time, months, possibly years, to work through the system. For now, the operational reality is this: USCIS is running at a different level of scrutiny than it was before, and the best protection you have is a thorough, accurate, and well-documented application. I want you to take a moment and think about what is actually at stake here. Your immigration status is not just a legal category. It is the foundation of your family's stability. It determines whether you can stay in the same home as your children, whether you can continue building your career, whether you can travel and return, whether your path to citizenship remains open. A fraud finding, even an incorrect one, can unravel years of effort. A denial at the wrong moment can separate families. I say this not to create fear. I say this because I want you to understand that the effort required to keep your case airtight, to work with qualified legal counsel, and to stay informed about policy changes, that effort is worth it. It is not optional anymore. It is essential. USCIS has referred more than 14,400 individuals to ICE since January 20, 2025, for public safety, national security, and fraud concerns. That number is not going down. The agency is not scaling back. And Operation Twin Shield has demonstrated that cases can be reopened, reviewed, and acted upon, sometimes years after they were initially filed. If you have a case in the system, you need to know what is in it. Here is what I want you to do right now. First, if you are currently waiting on a USCIS decision, make sure your attorney or legal representative knows about Operation Twin Shield and the expanded fraud detection posture. Ask them specifically whether your case has any documentation gaps that should be addressed proactively. Second, if you received any USCIS communication in the past 6 months that you have not fully responded to or followed up on, do that today. In this environment, delays in responding to USCIS can be misread as avoidance. Third, share this video with someone in your community who has a pending immigration case. They may not know that this operation is still active and expanding. That information could protect them. If you want accurate, fast, and reliable immigration updates, subscribe to Raymond Crivello right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential. Drop a comment below and tell me your visa category or the type of case you have pending. I read every comment, and your questions help me know exactly what topics to cover next. If this video helped you understand the situation more clearly, hit the like button. It helps this factual, policy-based content reach more people who need it. Stay informed, stay documented, and stay protected. I'll see you in the next one.